Done.
Okay. All right, Todd. Sorry about that.
All right, good afternoon. We'll go ahead and call the meeting to order. I'll start with the ethics statement. It's the duty of subcommittee members to avoid conflicts of interest and appearances of conflicts of interest in performing the duties as a member of the Diversity and Inclusion Subcommittee of the Issues Committee of the State Bar. Any member of the subcommittee who is aware of any personal conflicts or appearances thereof with respect to the matters before the subcommittee should disclose them at the meeting. And if you are aware of some, disclose them now. If they arise, let me know. Welcome. This is our third meeting. Obviously, we want to continue to make good progress here. We've had some good meetings thus far. And as I mentioned yesterday, we need to start getting close to the point where we're sort of putting pen to paper and making some recommendations, or at least getting some consensus around what may be acceptable for recommendations to the Issues Committee as we complete our work. And we've got several meetings left this year and we can fit some in, but I do want to start thinking about what sort of recommendations the subcommittee can start gelling around so that we can start knowing what we certainly might be able to recommend and what we believe we will be unable to recommend, and lots of folks may have views in between, but that's sort of where I'd like to start getting in the near future. I know we need to do some more educating ourselves, at least I do, about what may be best for the North Carolina State Bar. We're gonna take a look at today, excuse me, what 3 other bars have done who are in similar situations, and have some discussions around that. So I want to go ahead and start first by getting the minutes approved. You have the minutes for the January 12 and the February 16 meetings in your materials, and I will entertain a motion to approve those.
So moved.
Second.
Properly moved and seconded. Any discussion? Any changes? All in favor? Peter, we're going to use the poll, or we're going to not use the poll?
Todd, I think that Peter has left the room. I told him he could do so.
I'm still here, Alice, if you
Okay.
need it. If you just want, you can click over my name and hit more and make me the host, and I can launch the polls.
Okay. Happy to do that, Peter. All right, Peter, you're in charge. I know you love to hear that.
Yeah.
Go for it.
All right.
For whatever reason, I think because you were the original host, Alice, I don't have the polling feature. You probably do. If you want to click polls at the bottom, you can launch the poll if it's there. If not, we might just need to do a voice vote on this one, Todd.
That's fine.
Peter, I don't seem to have
Okay.
polling.
Okay.
All right. We can just do a voice vote or hand vote.
Okay. Apologies.
Motion to approve the minutes of the January 12 and February 16 meetings have been properly moved and seconded. All in favor, please say aye, raise your hand.
Aye.
Any opposed? All right, I believe that passes unanimously, Peter.
Yep.
All right, okay. I want to do one thing before we get into part of the materials that we have circulated to you all today. And with the able assistance and leadership of Leonore, we will walk through the reports and plans and initiatives of the various bars that we have sent you materials on. But one of the things that I wanted to get some input on before we move into that for part of the meeting is we've had a meeting, an organizational meeting. We've heard from Dana of the Missouri State Bar. One of the things that I want to make sure that we as a committee cover and consider and get input on would be the views and input from the pertinent stakeholders here. We haven't had a lot of presentations as of yet, and yesterday, as they always do, I got a very good recommendation from Carmen and Leonore that, should we consider, for example, the views of other stakeholders, in this instance, for example, like young lawyers who are members of this profession? Should we get input from law students, law schools? And then I thought, well, should we really be getting input from folks who might have a real interest in knowing exactly what we end up like the various affinity bars around the state, the Black Lawyers Association, the Women Lawyers Association, et cetera, maybe the advocates, maybe the Defense Lawyers Association. So I wanted to get some input from this group on the views as to whether or not we need input. I mean, obviously, we're trying to do things that are going to benefit not only the state bar and its membership generally, but also specifically those affinity bars have a vested interest in what we might recommend ultimately and where the issues committee and the state bar may end up. So I wanted to take a minute to just get the views of the subcommittee on whether or not we ought to hear from, in some shape, form, or fashion, other stakeholders, and if so, which ones? Floor is open.
I guess I kind of have mixed feelings about it, to be honest. I always think that additional input is good and helpful. I guess my concern is that I don't know, like how much time do we want to devote? How much time do we have to devote? Maybe that's a better way to say it. And I just have some concern about perfect being the enemy of the good, and whether or not we are would be better served to try to get something together and for them to react to first, rather than getting their input first. So that's probably not helpful, but that's just the concern that I have, is whether or not we're going to introduce the delay that is a bigger issue than the feedback that we would get at this early stage in our process.
Todd, Dorothy's hand is up, and Barbara's hand went up as well.
Whoever wants to go first, Barbara, or Barbara, go ahead, and then Dorothy.
Okay, so I had, I guess, a little bit of the same concern Ted had, but mine's a little different, because I feel like if we solicit, if we just go out and solicit open feedback, I think it's likely that many of those folks are not going to understand our mission, and they will think of us as the Bar Association, and we will get a lot of feedback and suggestions that are things that we couldn't do. And I just don't want groups that provide that to us to then think they were ignored. So maybe if we could, as Ted said, but for different reason, sort of narrow it down. And if we ask for feedback, at least, not have it be so broad and open-ended.
Okay, thank you. Dorothy?
I share some of the same concerns. I have a little bit of a question though, or a different kind of concern, in that I agree that we would be better served for having something together and providing it to folks, to whatever groups we decide or whoever we elicit their responses for input from. present something to them so that they could respond to it as opposed to something open-ended. And that part I agree with. The other part, though, is that while I want to be sure that we hear from certain groups, I also want to make sure that this is not an instance in which we end up excluding some group, by not asking or eliciting their input. So I know so when we come up with those, of course, those that you named out, Todd, those groups are the obvious groups to look to, the Black Lawyers Association, the women attorneys, all of those different ones. But like I said, I just want to make sure that we don't exclude anyone in our quest to really be mindful of inclusion and diversity and all of that. And then we end up going against it in some way. I just want to make sure that we don't do that. So I just wanted to point that out.
Others? Part of my reason for asking the question is I want to make sure that we are, as you say, considering the various views of the various stakeholders. I don't know whether it makes a difference whether we get it on the front end before we have something in writing, or whether we get it on the back end after we have something in writing. We circulate it to them and they give us our input, and we don't take their input. And then they say, okay, you didn't take our input, but you asked us for it. And I've also heard another reason is that I have had discussions with members on the council relative to the views of the various minority lawyers in the state relative to how they view the state bar. And I'm sure you guys have heard a lot of those as well. And so I want to make sure that we are being viewed as, to use one of my favorite words, in being inclusive at all stages of our work. And so I wanted to take some views of this committee, and I haven't chaired a lot of these, so I'm not sort of familiar with the notion that we put something, we put our recommendations on paper and then we circulate it to the various stakeholders to get their views at that point. Maybe that's the process, and that's fine with me if that's where we end up. But that could be problematic as well. If we circulate something, they give us a bunch of comments and we don't include those comments. So it's sort of a damned if you do, damned if you don't in some respects. But that was the reason I wanted to raise this issue. And if the subcommittee and its pleasure is that at this point we continue plowing ahead to come up with recommendations at some point, and then we decide whether and to what extent we circulate those recommendations or input outside of the committee, I'm fine with that as well. But I wanted to make sure that for some of the reasons we've discussed here, that we are not viewed as not being inclusive at every phase of the process. And so I think we can navigate those waters as we move ahead. But I don't want anybody I'd like to avoid a situation where somebody says later on, you didn't get our input, you excluded us, et cetera, et cetera. So I'm fine with where we are and we shall proceed accordingly. Did somebody else raise their hand? Gina, you're on mute.
Yes, sir. I agree with what Ted and Barbara and Dorothy said, and I wanted to give you an example of something that happened recently in ethics where we did exactly what you're talking about. It involved an opinion that we were considering about guardians ad litem. And we had subcommittee meetings about it. We had a draft opinion, and then we talked with the guardian ad litem office and discovered that what we were doing might affect their funding. And so that was not anything that was on any of our radar screens, but we did that before we published it. We've gone back to the drawing board and now we're factoring that in. So my point being that there is a precedent for doing it that kind of a way. And I think our work will move more expeditiously if we don't get too many cooks in the kitchen in the front end, for the reason mostly that Barbara raised, which is all the groups that or a lot of the groups that you mentioned specifically, like law students and young lawyers, won't be as familiar with the limitations of the state bar and what our mission is. And so I would be afraid that we could get off kilter. But I think once we do submit this to stakeholders, once we do issue an opinion, I think it would be incumbent upon us to write the stakeholders if we did not incorporate their comments and tell them why. I don't think we can ask for people's opinion and then ignore it, or let them believe that we ignored it without spelling out the reasons that we were not able to include it or chose not to, based on some rationale that they weren't factoring in. Thanks.
Okay, that's very helpful. All right, we will get on to the other reason for meeting today, but I understand where the subcommittee is at this point. And there are ways to navigate the concerns that have been raised here today. I'm confident that we can do that. So putting that aside, does the, as I said, I want to get to putting pen on paper soon. Is there any view on the subcommittee that we need any specific education resource to share their views with us before we move to the next phase, which I think is, if we're going to do this this year, and I'm in favor of, quite frankly, I'm fully in favor of doing it right instead of doing it quick, as they say. And so if it takes us a little longer, then I'm fine with that. But I'd like to get it done sooner than later, and get it to Ms. Christie and the Issues Committee as soon as possible. So we shall proceed as viewed, as the views of the subcommittee have been expressed today, and we shall navigate things as we move forward. So with that, I will ask Leonore to share with us a slide deck that she and Carmen and others have put together to walk us through the various reports and initiatives that you have in your materials today, and we'll talk about those at the end of that presentation. Leonore?
Yeah, great. Thanks. Carmen's going to share her screen. She put visually together what we were trying to digest, as it were, from the various jurisdictions about what, in particular, Florida, Oregon, and Arizona have done in the DEI space. All three bars whose recommendations you had in your materials are integrated bars. And what that means is that they perform the regulatory functions for their jurisdiction, but they also do other programs to enhance professionalism and competence along the lines of what we here in North Carolina would expect the North Carolina Bar Association to do. I did send a request out to the NOBC listserv group that we have, which is a group of bar regulators, to get seeking information from them about what, if anything, their states are doing in this area and what they wanted to share. Some of the responses related, as you might expect, mostly to rule changes and 8.4G and other things that we are studying in other areas here in North Carolina. But in particular, Arizona reached out, and I had a conference with the diversity officer for that bar to share details about what they were doing, and you have Arizona in their materials. And also in connection with a breakout group from the Conference of Bar Presidents on Diversity and Inclusion. I had the opportunity to speak with the General Counsel for Florida, which is another integrated bar. I have not spoken with anyone from Oregon. I give you that backdrop to understand that obviously there is a distinction between what some of these integrated bars might be able to do, different and apart from what the state bar could do as performing the regulatory function only. And I would just say for this group, as it goes through its work, I don't think there'd be any harm in suggesting that things that belong in the other space that you've seen, making sure that the our bar association arm is aware of it. With regard to Florida in particular, I was intrigued when I was asking their general counsel about a leadership academy that they have in Florida, which is basically designed to put into the pipeline for bar leadership folks from underserved populations and diverse backgrounds. And her thoughts about whether that's something that sits in the bar association side, which in my opinion, it arguably, strongly arguably could, or was in the realm of what they do as a regulator. And she actually thought that when it comes to fairness and equality in the justice system, that it fits squarely within what they did within that context. So I shared that with this group just to put out there that even the integrated bars are thinking about Keller and how it relates to their different roles and functions. I think because they're integrated, perhaps sometimes they move some things into the regulatory space that we wouldn't even touch because we're separate here in North Carolina. With that little preface, I just want to say, in reviewing what these 3 states have done, I mentally think about everything that's included in all these lists as 4 categories. The education category, where they've made a recommendation seeking to educate either the lawyers or the public about DEI. The evaluation category, and that's either in evaluating DEI in history, in membership, in staff, in vendors, in outcomes. Encouragement, which is trying to get folks to participate in either the practice of law itself or the governance of the practice of law. And then establishment, various programs and systems that foster diversity and inclusion around the practice of law. So with that said, Carmen, if you would go ahead to the first slide. And this is a summary of what the State Bar of Arizona's recommendations include. And in a more drilled down fashion, we have 6 different categories, and you see them on the screen in front of you: education, governing documents, membership, outreach, service and leadership in the bar, and then the state bar entity itself. With regard to Arizona, and I'm not going to read all of their recommendations, you have them in their materials and you see them on the screen. What was particularly unique about Arizona, as distinguished from the other 3 jurisdictions you have to consider, is they were the ones that were strongest with regard to CLE for DEI, and in particular, this idea that there should be a CLE requirement around DEI. And I think subcommittee members will certainly remember that Dana Cutler talked with us about what Missouri is doing in that arena and space as well. Another aspect of Arizona that I thought was unique was their desire to actually develop as the entity CLE programs. And as those of you who cross paths in the PMBR space know, that's not something that's particularly attractive here in our jurisdiction. And also this idea that they would be setting aside funding for CLE programming put on by other smaller bars. Also unique to Arizona in the service and leadership context of their recommendations was their recommendation to reach out to law students and affinity bars and try to put those 2 entities together. I presume that that is their pipeline program or an aspect of a pipeline program that they like to have. And then thinking back to some of the comments that this subcommittee and guests talked about at that first meeting, I thought it would be important to note their idea of soliciting testimonials about service on the committees to encourage others to apply. And then they also had a recommendation to add law students as ex officio members where appropriate. I thought that was a particularly unique idea that Arizona had. With regard to the state bar entity category of recommendations in Arizona, and thinking about what this subcommittee I know is considering around studying the history of the state bar here in North Carolina, is this relationship that they have developed with the Arizona State University Center for the Study of Race and Democracy to help them analyze their demographic data that they collected through the survey. So that's not a direct line between what they're doing and what the subcommittee had discussed previously here in North Carolina, but it is an interesting idea that is unique to Arizona that they are pursuing in furtherance of the goals that they have around the DEI space. And also they are unique with the idea of creating a central calendar of events and programs around DEI. Again, it's always important to remember that they are an integrated bar. And when I think about particularly that recommendation, it probably centers from what they might be doing on the more general professionalism and competency arena of their work. And then they also, with regard to demographic information of their membership, specifically spoke to retaining demographic information related to disciplinary actions, which is something that was unique to their list in Arizona. If we could move to the next slide. Florida has a much shorter list of recommendations, a lot easier to digest, I think, and they're pretty high level. They have in their education arena the recommendation to include diversity program within their schedule of events when they host things. And that was a unique take on the education space that I didn't see in the same way with Arizona and with Oregon. And also they have, similar to Arizona's idea of funding, a grant program for voluntary bars to try to provide support to them when they host seminars, summits, and symposia and other events with regard to DEI. I didn't have very much more to point out about Florida. I think it's, like I said, a lot easier to digest because their list was so short and concise. Oregon, if we could go to the next slide, as the slide depicts and as the pages in your materials reflect, by far has the most detailed plans about what they want to do and why. I think that's mostly because they have the outreach segment of what they're doing, and it's so much more detailed in terms of reaching out to the community and the public as distinguished from the other bars and what they're doing in the DEI space. And even in their educational list of recommendations, what I had highlighted as unique about them is this idea that they want to increase public education and target media outlets with legal trends and issues that affect underserved communities. Again, Oregon's sort of looking out beyond the membership and the rules and the regulations that govern the entity and more toward what do we do as lawyers to foster the administration of justice in society is weaves through their recommendations in a way that it does not with regard to the other jurisdictions. Down in their service and leadership section, they had the recommendation of encouraging diversity of volunteers for editorial review boards and authors for legal publication books. I didn't see that in any of the other recommendations from the other jurisdictions, and Oregon is fairly unique for including that among its recommendations. And then in their state bar entity recommendations, they had a review of their admissions processes to determine whether applicants to the bar are treated equally and fairly. Obviously, that sits outside of what this group would do, but Oregon is unique in that it includes that in its recommendation. And also this idea of who has access to the public protection programs that the bar offers, whether English language learners could fairly access those things that we as a state bar entity, like let's say making a grievance complaint, have available out there to help protect the public. Do diverse populations have access to these things so that they're meaningful? And then also this idea of ensuring that if you choose to exercise the use of a public protection program, that when the public does so, that process is fair, safe, and welcoming for all. But we can go to the last slide. And then this last slide just shows in a really digested format what generally 2 or more of these bars are doing in the DEI space. And you can see from an education standpoint, they're all doing something to their members about DEI. They all have some recommendation to increase diversity of education and faculty. And Arizona is listed for the mandating DEI CLE, mostly because they are unique in that regard. And so that should be noted that though there is consensus around the idea of DEI with these 3, only DEI CLE in education, only one of them thinks that it should be mandated. In the governing documents, you can see that Florida and Oregon both believe that they should say something about diversity and inclusion, or ensure that that's considered in terms of how they're structured and written. In the membership space, it was only Arizona that talked about surveying its membership to gain information about the perceptions and experiences of the participants in the profession. As I discussed at length, Oregon is unique in its focus on outreach. All 3 of the jurisdictions have recommendations around programs and strategies to increase diversity in bar leadership. And then you can see that in the state bar entity space, the 3 that we're looking at today, while 2 have each of the following items, none of the 3 agree that all should be recommended in their space. And that's adopting a written diversity statement, collecting demographic information about the membership, and considering diversity in choosing state bar vendors. And Todd, that is our summary to try to help the mass of materials that I know we shared this quarter with the subcommittee.
Thank you, Leonore. Carmen, I want to give you an opportunity to put your voice in the room since you have put together the materials as well, and anything you want to add to the presentation, we'd love to hear from you.
Thank you, Todd. You've known me a while, and you know that if I have something I think is valuable, I'll elbow my way in there. I think Leonore, she summarized that very well. And there are a lot of interesting components of this that I hope the subcommittee is able to select some that you all believe are appropriate for us to pursue. But I don't have anything else to add, but thank you.
Can you, I do want to return to the slide deck. Can you put the last page up? Because I do want to ask the subcommittee about some of those issues and ask you about them as well, you and Leonore about them. Of the items listed here, are there items listed on here where if we were to consider them or try to consider them, that Keller would be an impediment to our doing so? Carmen?
So, I mean, I believe that's a difficult question to answer. There are two questions. One is, could someone argue that this was inappropriate under the Keller analysis?
Right.
And then the other is that likely to be a persuasive claim? And I think those are two different questions.
Agreed.
I think we're at a stage in our society where people tend to be quite reactive to opinions that they do not share. And so I think there are a lot of things that could prompt a Keller-related challenge to state bar action. I think that educational programs in this vein would be very hard to challenge, even the mandatory ones. Now, Catherine Jean may not agree with me, but I just believe that as long as there is a nexus between enhancing the quality of legal services provided to the public and enhancing the performance of the profession, that the educational pieces are probably on the safe end of the spectrum. I think any sort of official statement by the state bar, I'm kind of skipping down now to the
Sure.
final piece, any sort of written statement by the state bar about a view on diversity and inclusion or commitment to it, that would have to be crafted fairly carefully, just because that is just a position statement essentially.
Right.
But I also think that can be done. I think I mentioned, I don't believe it was in this subcommittee, but perhaps in another one. I think it was when we were talking about the preamble, and I noted that there are very non-controversial federal agencies that have published on their websites official statements about their commitment to diversity. So just doing that is not an inappropriate thing for a government agency, was the bottom line. So there's nothing on here that jumps out at me as problematic in terms of Keller. I don't know, I haven't really looked into carefully how that might apply to trying to take a demographic survey, trying to compel demographic information. That might be an issue. That's just not something I've examined. Does that answer your question, Todd?
Yes, that's very helpful.
Todd, can I say about the collection of demographic information?
Yes.
I
was going to jump on that one. So yeah, go ahead.
I'm not aware of any, like I said, I didn't speak to Florida, but I did speak at length in Arizona, and they don't mandate the collection of demographic information. I think that speaks to Carmen's sort of gut concern about if there's anything that she would want to look into further, or we would need to think about further, it would be that. But what Arizona did share with me is that for years they had on their license registration renewal a demographic question, and you could answer it or you couldn't. It didn't really matter. And then they got about 20% response. And what they've done is they still don't mandate that information, but they just change the way they ask for it. So now you have to answer, even if you choose not to answer. And that has resulted in a switch from about a 20% information grab to 75 to 80% response.
On the demographic data collection, are you just describing what sort of a voluntary self-identification process?
That's what it, and they've had it for years.
Yeah.
But they've switched the way they treated it. So I wanted to weigh in for two reasons. One, to suggest that the fact that Arizona really wants this information but hasn't switched to mandate getting it suggests that they might have a little concern about the ability to mandate that information being given. But then also to just show that if the subcommittee decided it wanted to collect the information, Arizona is a good example of a way that the question might be asked to increase the likelihood that people might choose to provide it.
And just to clarify, Leonora, you're saying that you must answer the question, but one of the options is I prefer not to answer, right?
Basically,
you have to respond, but you don't have to self-categorize if you choose not to.
Right, you have to respond, but you don't have to answer.
Right. And I know that the state bar, as I understand, oh, I'm sorry. Dorothy, you got your hand raised? I can't see you.
Yes, sir. I have a question for either Leonora or for Carmen. When you, I guess, Leonora, you talked to some of these entities in your discussions with them, because I don't recall seeing any information in the materials that we have. I was already very familiar with the Oregon materials because I'm chaired a subcommittee with Indigent Defense Services, in which we just created our diversity statement and plan. Moving forward, we just adopted it actually on last Friday. And so Oregon was one of the plans in which we looked to for a lot of that. So that's why, disclaimer on the material, I'm familiar with those materials, but not so much with the others. But in speaking with any of these entities or in the materials that you've reviewed, did any of them include in their plan or proposals or recommendations a DEI officer or set aside staff person to be able to manage all of these plans and recommendations and things?
Yes, I have to pull up my notes to identify which one. But yes, I think, well, clearly Arizona, because that's who I spoke to. They have
okay, I got you.
Yeah, and I think Florida does as well, actually. But
Okay.
I'm going to double check that.
Okay. The reason why I asked that question is because I am, my starting position is definitely in favor of a statement, a diversity statement, of course, based on a lot of what Carmen said and just my research in this area. And over this time period, I've been working on these things. Folks, the general public, as well as our membership, is always enlightened and encouraged by a diversity statement. To know that there's a commitment there. And then I also support a plan moving forward in order to fulfill whatever mission and things that's included in that statement. So I'm in support of those, but being in support of those means that is going to create some work, a lot of work for someone at the state bar. And so that's why I asked the question of whether or not these entities had a DEI officer or staff person, and we might want to strongly consider that here, if we're looking, towards that direction, because as we all know, all of our folks at, our Office of Counsel and otherwise is busy all the time. And so if we're going to have a statement and a plan and have someone that is constantly reviewing it and making sure, doing an outreach and checking this data and all of that good stuff, you want to make sure that it is actually done and not something that's just on paper, but it is actually done, and not create more work for everyone else. And so I just throw that out there.
And it's Florida, Dorothy. Florida does have in its recommendations the same thing.
Awesome. Thank you so much.
I'm sure the misbehaving lawyers of the state would be fine for Leonore and I to do this most of the time.
Dorothy, is another way of what you're saying that the state bar would need to fund this position because it is the creation of a new position and someone will need to be able to attend these issues sort of on a full-time basis so that we just don't come up with an excellent plan and an excellent statement and it just sits there and gathers dust?
Yes, sir. You always know how to rephrase it in such a more eloquent way. Yes.
I doubt that, but I guess that raises the question, and maybe I don't know if Alice is on, and Catherine, or maybe Carmen. Any impediment in your view with respect to using state bar funds to pay for a D&I coordinator, officer, et cetera?
Well, Todd, that's kind of a complicated question to answer. If we're talking about adding a staff person, then I have budgetary constraints on a go forward basis. We would have monies available for new positions. Our budgets are fairly tight now from year to year. The most expensive thing we do is hire people and pay them benefits. But, depending on the parameters for the position, if it was an important initiative of the council and it needed staff support, then we would enable that as best we can.
Yeah, I was asking more whether or not there's any legal impediment versus a monetary impediment. I assume.
Well, I'll let Catherine, if she's on, talk about legal impediments to that. I mean, I think it's kind of the same analysis that Carmen was using.
Right.
If there is that germaneness to the regulation of the practice of law, then I think we can justify the expenditure.
Okay.
That's it. Oh, I'm sorry.
Go ahead, Carmen. Yeah.
That's just that's exactly what I was going to say is I think it would all depend on the job description. I think we would have to put some serious thought into how that position was directly tied to the core mission of the agency. And personally, I think that is absolutely feasible, but we would have to do that work and not just have it be like a free floating, we'll figure it out once the person is in place.
Right. And Catherine, I'm coming to you in just a minute. Leonore, in your discussion with Florida, is it your understanding, because they gave these recommendations in 2010, that they have a D&I person in place now? Or you didn't get down in the weeds that far?
Right. The discussion I had with Florida was really specifically targeted. I didn't ask, but I'm happy to reach out and find out.
Okay. Catherine.
So I had a question about the recommendations and initiatives that were instituted in these 3 states. Has there been any, or is there any evidence that they have the desired impact? And was there any commitment when they made these recommendations to actually monitor to see if they have the desired impact?
So I don't have the answer to your question about what the impact is. I know that Florida has done some evaluation of what it's doing in the DEI space and feels like they are making positive inroads in a way that they would want to, but I need to reach out to them to get more specifics about whether they have data and metrics that allows them to actually track what they've done. I think Arizona does have some idea about some things that it's done, but I have to review my notes again from that discussion to think about it from that vein in terms of what the results are, to the extent that they have them. I do know that Arizona, the representative from Arizona talked a lot about how the lawyers very much believed that moving in this space is something that was required for the profession as a whole, and that was what was driving their desire to move and do things and come up with recommendations around DEI.
mean, Catherine, that's an excellent question. I mean, I guess the question is, how do you measure success in this space? And I can say that, in my firm where I've been there for 35 years, I've been working on these issues for 35 years. And I can't say whether we've been successful or not. Is it hiring, 50% more women and diverse lawyers, or is it something different? Is it having, diverse attorneys in the leadership ranks, over the practice groups, et cetera? So one of the challenges I have found is that what's the definition of success? If you put a numeric number on it, you probably run afoul of some, discrimination laws. If you say, success is 10% more lawyers. So, I mean, that's been one of the challenges I've heard constantly, is that how do you define success? And a lot of folks will say, well, if you had, no diverse lawyers and women lawyers, and you implement these and your numbers go up, perhaps that's success. Others will say there's success if you get folks into the leadership ranks. And so that's a great question, and one that I have always struggled with, quite frankly.
Todd, you've got Barbara's hand raised.
I'm sorry. Thanks for helping me. Barbara and then Dorothy.
I think Dorothy's was up first.
I'm sorry. I apologize. Dorothy, go ahead.
No, it's okay. I understand the question about what it means to be successful. I think that, and I think this is great conversation that we are having about it. I do want to just caution or encourage everyone to look at that question about success more holistically and not on the individual pieces. If we do end up establishing some sort of plan, I would hope that the plan would include some data collection for sure. And so you would have the data collection as in the numbers that you speak about, Todd, just the increase in numbers in general of these different groups, the underrepresented groups, increase in leadership on all levels, increase in membership in different ways as far as like State Bar Council, all of those different entities. You would also want to see increase in numbers of things like speakers at CLEs and, folks who produce articles and different things, just all. So looking at all of those different things, I know it may seem, if you look at one individually and say, oh, the number may have gone up, but what does that really mean? But if you see the numbers increasing across the board, and then you continuously have get feedback from your membership and from the public. I think that you have to look at all of those different pieces, which is why I strongly encourage that data collection to be done. And then there's a constant review of those different pieces of data. And so you can look at it in a more individually and holistically. And so you'll get a better picture. I don't think that there is a absolute answer to success, but I think that when you look at all of it holistically and as a whole, you will at least get a better picture and be able to see where the areas that you would need to improve, which is another reason why, like I said, I think it's important to have a designated person that is there to make sure that they're constantly looking at all those different pieces.
Barbara?
I think, that informally we are trying to increase diversity. It's discussed at almost every committee meeting, but I think at some point this committee would try to define what diversity means in the context of what we're talking about, because we talk about a lot of things. We talk about diversity geographically. We talk about the type of law practice. We talk about the size of firms. We talk about race. We talk about sex. We talk about age. So a lot of different things we talk about as we're considering things at the state bar. So I'm not sure, for when we use that term, we probably would need to be in agreement on what it meant to us if we were going to start with.
I guess, which is my way of saying maybe you start with a statement and we start with agreeing what we're talking about. And it goes back to the data collection too, because if what we say is we need to be more representative of the lawyers of North Carolina, how do we know what that is if we don't know anything about them demographically?
Okay. Thank you, Barbara. Any other hands that I've missed? Any other?
John's hand is up.
Go ahead, John. I'm sorry. Go right ahead. John. You're on mute.
Thank
Okay.
you, Todd. I'm not in disagreeing with anything that's been said, and along the lines of what Barbara was getting into, you know, I think we might have to have a kind of a two-part focus here. I think the idea of a statement certainly is necessary, but when we start implementing a plan, I think that maybe the initial focus needs to be the state bar itself as an entity, and then to focus on the membership, because we do not have homogenous districts. I had the opportunity to visit quite a few of the districts, and when you compare, say, Durham and Waynesville, or Hosky and Cullowhee, they're very different. In a few districts, we actually have a great deal of diversity and inclusion. In some other districts, we have virtually all white membership.
Right.
Some we have very few females. So I think that especially before there's any kind of a mandatory effort, we need to analyze what the membership consists of. But I think really more important than that right now is to develop a statement and then implement that on the state bar as an entity, so that we ourselves, not only the council, but the staff, reflects what we want the membership to see. Because until we do it at home, we're going to have a difficult time selling it to the membership.
Any other hands that I don't want to make sure I don't miss anyone.
I don't see any hands raised at this time.
Madam President, maybe this is a good opportunity for you to answer a question for the committee. My understanding is that our charge is to make recommendations, whereas there's sort of a consensus that we need potentially at some point a diversity statement on paper that speaks to all the issues we're talking about. And my general understanding is that is beyond the purview of my subcommittee, but it would take the form of a recommendation to the issues committee that the state bar adopts a diversity statement. I'm looking for clarity here.
Well, I'm not sure I can give you that, because we, I don't know that we have, you know, all those. Certainly we wanted recommendations. If one of the recommendations was that a statement be adopted, I think it would be appropriate for this committee to recommend what that statement would be, and then take it back.
Okay, maybe a proposed statement attached to our recommendations, something
Correct.
along those lines. Okay.
Yes.
All right, that makes sense.
Okay, thanks. And I've got to jump to another meeting.
No worries. And I'm respectful of everybody's time. I know we listed an hour, and we're about to wrap up. The one thing I'm trying to get some takeaways, and I just want one today, and because it's 2:31.